Welcome to our session today of the Charleston School of Law Professionalism Series. I'm Ed Westbrook, one of the founders of the law school, for those of you who haven't had a chance to meet. And it's my pleasure to be here today to introduce to you two super lawyers to speak to you about professionalism and ethics. And I call them super lawyers for two reasons. First, they've been named as super lawyers by the publication aptly titled Super Lawyers. It's a national publication that goes around to the lawyers in every state, solicits evaluations from the entire bar, and then names those few lawyers who are at the pinnacle of their profession in the state as super lawyers. And we have two of them with us here today. But they're super lawyers, in my estimation, not because of the millions of dollars of verdicts they've won in civil cases or because of the acquittals they've won in criminal cases for defendants who other lawyers would give up for jail, but they're super lawyers because they've achieved what they have achieved while keeping the highest standards of professionalism and ethics in mind. They know what you're going to learn when you get out in the profession, which is that a slick lawyer can get by once or twice in his or her career, but once you're caught, that will follow you throughout your career. But a super lawyer is a lawyer who can be successful, be ethical, and professional at the same time. A lawyer whose word is his bond, who can settle cases worth millions of dollars on a handshake. That's what makes a super lawyer, in my estimation. Our two super lawyers today are first from Charleston, Mr. Gedney Howe III. Gedney comes from a long line of famous South Carolina jurists. Gedney's father, Gedney Howe Jr., was a legend in Charleston legal circles, and his uncle, Arthur Howe, was similarly famous. We have a scholarship here at the Charleston School of Law in Uncle Arthur's name, established by the Howe family, for which we are very, very grateful. If there's an important case going on in Charleston, a big stakes case, you can bet Gedney is in the middle of it. He has won more verdicts and settled more cases than probably any other living lawyer in the Charleston legal community. We're very happy to have Gedney with us here today. And joining him on the stage with us is Mr. Cam Lewis. Cam is from Columbia visiting us today. Cam is one of the most famous lawyers in Columbia. He is a super lawyer in Columbia. He's not only a lawyer's lawyer, he's a judge's lawyer. And what I mean by that is when judges get into trouble, they come see Cam Lewis because they respect his view on what they need to be doing. Cam has argued cases in state and federal courts throughout the country. He's been at the United States Supreme Court in the famous case of Lucas versus the Coastal Council, which established that the state cannot so regulate your property as to remove all value without paying you for it. And Cam won that case. Cam handles cases large and small, and each case is as important to Cam as it is to the client, and that's saying something. I've heard judges say very affectionately that Cam is a bulldog in the court. What they mean by that is that Cam is smart, he's effective, he's impressive, and if you're his adversary, you'll understand what we mean when we say that Cam is a bulldog. Now, the biggest problem that two super lawyers have when they're on the same side of a case or sitting on the same stage is deciding who goes first, because they know that there's a great value in a courtroom to opening, and there's also a great value to making the closing argument. So I think they flipped a coin and they've decided that Gedney's going to go first and Cam is going to close. So I present to you today two super lawyers on professionalism and ethics in the profession. Please welcome them.
Cam made me go first so he could be in the seat of criticism. He does that very well. So you look forward to critical remarks on what I'll tell you. We're going to talk about ethics. We're going to talk about how it impacts you all as lawyers. And the first thing, there are two ways to look at it. I'm going to talk to you first about the rock in the road. But you're walking down the road and there's a rock in front of you. The number one thing you want to do is not to stump your toe. And ethics, when they're teaching you ethics, they're generally trying to scare you. They're trying to inform you, but they want to make sure that when you see that rock, you not only don't stump your toe, but you get on the other side of the road as far away from it as you can. Now, I think that's the safest place to be, but it may not always be the best place to be in terms of looking out for your client. Now, in the stump your toe approach, we've got a lot of information out there that's designed to teach you how to stay out of problems. And I looked in the ABA Standing Committee for Professional Discipline, and when I read you these articles that are available to you, you can hear the little sense of, you better be real careful, you better be a little afraid. Top 10 traps for lawyers, 5 tips for lawyers, do's and don'ts, professional responsibility reminders, bad things happen to good lawyers. All right? What message is that sending to you? All right? Disciplinary actions. So there are a lot of publications out there. These publications are directed towards informing you, and I think putting you on notice that anywhere in this area is risky, is potentially dangerous to you. You might stump your toe. Secondly, you can write for advisory opinions. Before you put your foot in the water, you can write and ask, can I do this? You ask for the Professional Responsibility Committee. I'm going to give you a couple of recent opinions, just some summaries of them to show you how people might stay out of trouble. Lawyers are not supposed to record conversations. And you had a litigant in a domestic dispute who wanted to tape the spouse and said, well, I'm not doing this as a lawyer, I'm doing this as a litigant, and I want to be able to tape the spouse without their permission, which he can't do as a lawyer. Well, before he took any action, he's very careful. He wrote a nice letter. He explained exactly what he was doing, and to see whether he could get permission to do that. And they said that was okay, because he wasn't acting as a lawyer. They talked about, there were one guy, a lawyer, represented somebody as a defendant in a DUI, and then the other side of it wanted him to represent him in a civil case. They talked about how you get a waiver, and once you get that waiver, you're free to do that. Those set up for you how you can safely set your course through the ethical waters and avoid all problems. It's just got nothing in the world to do with practicing law on a day-to-day basis. What we do ethically, and what we use the ethics for, is to set parameters of your conduct, but don't think for a minute they aren't a part of the adversarial system. Don't think for a minute we don't fight over these things like we fight over everything else if you're in the litigation part. Now we're going to focus on one area. 4.2 reads, in representing a client, a lawyer shall not communicate about the subject of the representation with a party the lawyer knows to be represented. Now, on the face of that, that would seem pretty damn simple, doesn't it? I mean, what's so hard about that? Boy, you just don't know how hard that is. My question to you is, what's a party? Who's a party? Now, I'm a plaintiff's lawyer. Before I bring a suit, I look out and say, who do I want to talk to? And am I in any way prohibited from talking to these people? Because the ethics are going to come back and bite me if I do it wrong. So it says here, to communicate with a party. Now, to have a party, you got to have a lawsuit. If you don't have a lawsuit, it is my position, you can go talk to just about anybody you want to talk to. And I'm going to give you a simple example of that. When the truck driver has a wreck, and if you bring your lawsuit the next day and you sue the company and the truck driver is clearly a party and you can't talk to him, can you? Not according to this rule. But if you don't, if you just wait and get your investigator and learn about the case and then contact the truck driver, he's not a party. And you can talk to him freely. And you can ex parte talk to him. Now let's talk about ex parte. That means I don't have to tell the other side I'm going to go talk to the truck driver. That's what's important in all of this. Because once I tell the other side, they marshal their arms and they're out there just like I am. I want to be able to move forward with the investigation of my case to the extent I possibly can, unaffected by the opposition. I want to move ex parte if I possibly ethically can. So what do? I think, well, this truck driver, they aren't going to fire him for a week or two, but this was pretty bad. I think I'm going to wait maybe a month, maybe 2 months before I contact him. Because by then he's going to probably be fired because his driving record reflects this is his third accident. And the insurance company is going to insist on him being fired. And then when I go to see him, what is he? He is a disgruntled former employee, the best witness in the whole wide world. The only thing better than that is a mad spouse, all right? But I'm sitting back and I'm waiting on him to be terminated if possible. In any event, when I go to him, I haven't said boo to anybody. I haven't told the insurance adjuster. I haven't told him. He's not represented because he doesn't have a lawyer. He's not represented and he's not a party because I haven't brought a lawsuit. So I go there and I get a good statement out of it, hopefully, because he's been fired and he's mad and he says whatever he says. I get this statement out of it. Then I'm in a position tactically of saying if I sue the company, I can sue just the company. But then the statement I got from this guy is not an admission against interest because he's not a party. And he wasn't a managing agent. You all know that admissibility question, right? Okay? So he's not a managing agent. He's not a party. So I can't get in as admission against interest. So what do? I join him. I make him a defendant. I can do that. I mean, he was driving the truck that caused the wreck. Sue his employer and sue him too. Then I get in the statement that I've waited on, my ex parte statement. I get it in as an admission against interest, and the judge explains to him it only comes into the driver, it doesn't come into the corporation because he wasn't a managing agent, but I'll take that charge all day long to the jury. Because once they hear it from one, they're going to impute it to both. Now, the next area we talk about are actual employees of the defendant. And boy, you don't know how these battles rage. The defense position is if you sue in a hospital, they represent everybody who works at the hospital is their absolute client. All right? And if they were right, I couldn't talk to them. Because under that rule it says they're a party. He represents them. I can't talk to him without his permission. Well, thank goodness that's not what the rules say. But it is, as we'll end on, sort of clear as mud. What you're looking for in terms of doing your investigation, all of this is about getting an edge, okay? All of this is about getting an advantage. All of this is about how you can understand these rules, not to distort them, not to misuse them, understand them so that you can, in fact, use them to your client's advantage, how to be appropriately aggressive in getting that edge. So you want to go talk, and the best example is a nurse. You brought a suit, so there's a lawsuit pending. The suit is against the hospital, all right? And you know that the defense lawyer is going to, if you ask him, if you say, can I go see nurse so-and-so, he's going to say, absolutely not. She is my client, all right? Now, if you look at the rules, what the rules tell you, there are two kinds of employees, present employees, former employees, all right? Generally what the rules are going to tell you is a former employee is fair game. You can go talk to a former employee ex parte without anybody else's permission. You have to be a little careful what you ask them. You can't talk about trade secrets. You can't talk about what the lawyer told them in confidence. You can generally go to that former employee, no matter who it is, no matter where they are in the food chain, to get facts about your case. Now, what about a present employee? When you sue the corporation, does that then bring under the umbrella everybody at that corporation? When you sue that hospital, does it bring everybody under that hospital as a client of the defense attorney? Absolutely not. No. What the rules tell you, and these are cases and opinions from the disciplinary council, what they tell you is you really got two groups. You got managing agents. Remember what managing agents can do? They have a very important role in the law business. All right? They can make admissions against interest. They can bind the corporation. All right? Their agents, the things they say as agents become the speakers of the corporation. Other employees, and which is where there are many of them, don't have the authority to bind the corporation. For example, you wouldn't expect a nurse to be able to bind the hospital. You might expect the head of the nursing department to be able to bind the hospital. So you look at this when you're out investigating your case, even after the litigation is brought, and saying, who can I go talk to ex parte without permission? Generally what you're going to see is that this line is drawn, and state after state the line is drawn that says if they can make an admission against interest, if you can take their testimony and use it directly against the corporation on behalf of the corporation, then you can't talk to them. That is in fact a client of the defendant. If there are many, many witnesses that you can go see that are not legally in a position of binding that corporation, then You can go see them, develop your case, and turn them into favorable witnesses for your side if you possibly can. Now, there's a little twist in here. They say to the defendant, you can't tell all of these people not to cooperate. That sounds pretty good from a plaintiff's perspective. The defense lawyer cannot go to the employees and say, do not cooperate. That's against the rules for him to say that. He can say, which is pretty much the same damn thing, you don't have to cooperate, and as your employer, we don't want you to cooperate. All right? So once that word gets out, you're not going to get anything out of anybody. All right? So what you're doing is thinking like an advocate. All right? Thinking like an advocate. You've got this set of facts. All right? And you're saying to yourself, well, how do I best develop them? How do I get an edge? How do I put them in the most favorable possible light? The first thing you want to do is contact witnesses and be the first person to talk to them and be the first person to hear what they've got to say and develop that into the theme of your case. If you have to go to the defense lawyer and say, I would like your permission to see the nurse on hall 3, I can tell you what he's going to say. First of all, he's going to say no. Then he's going to run immediately to her and tell her, I can't tell you not to cooperate, but as your employer, I'm telling you I don't want you to cooperate. And you're a dead duck. You're getting no information. You've built in a stone wall to yourself. Now, this is where I think the stone in the road, and this is how trial lawyers think, okay? This old bulldog over here will do this to you in a skinny minute. What I'm teaching you, what I want you to pick up, the thought is, how do you take that stone in the road and not stump your toe, right? And then pick it up and hit the other guy in the head with it? How do you turn the rock into a weapon? All right? Now you do that by understanding the rules. I'm not telling you all about these rules to say distort them, ignore them. I'm talking to you about them so that you'll understand how you can be an advocate within the confines of these rules, and to say to you, advocacy, the adversarial system is alive and well in the disciplinary rules. We're fighting over those too. Now, the former employee, I'm going to touch on that. We've got people that we can talk to before litigation is brought, all right, pretty wide open, don't have any parties. After litigation is brought, you've got employees who can make admissions against interest that you can't talk to. You've got everybody else that you can talk to. And then former employees. And the way they say that is, the disciplinary rules do not apply to former employees, and there is no prohibition against ex parte contact with former employees, because what they're saying is the rules don't even apply, because as former employees, they're not agents. At that point, they're not agents of the corporation. They can't bind the corporation, and therefore you're in a position to talk to them. Now, the most surprising and interesting part of what I learned in getting ready to present this to y'all, this concept to y'all, was that South Carolina is different. And South Carolina has a rule that I think is clearly wrong, and Professor Freeman, who writes for the law school, the Columbia Law School, wrote a nice long column about it, and he concluded they were wrong too. And I want to talk with you about this because this is the South Carolina rule. In 1991, the ABA held, quote, quote, prohibition of Rule 4.2 with respect to contacts by a lawyer with employees of opposing corporation does not extend to former employees of that party. That's what we just said. That's pretty clear. 1991. ABA said in a second opinion that same year, this is the National ABA, it should be noted that 4.2 does not prohibit contacts with former officers or employees of a represented corporation, even if they were in one of the categories with which communication was prohibited while they were employed. All right? So if they were a part of the managing team and you couldn't contact them when they were with the company, they were managing agents and could make admissions against interest and could bind the corporation, and therefore you were prohibited from seeing them. Once they become a former employee, that prohibition goes out the window because they're no longer in that position. All right? That's the ABA. In a 1995 opinion, the ABA correctly noted Rule 4.2 is designed to protect against disclosure, not designed to protect against disclosure of prejudicial facts. If an employee cannot by statement, act, or omission bind the organization with respect to a particular matter, then the employee may be ethically contacted by opposing counsel. That's me. I'm going to go see him and talk to him and not ask your damn permission to do it. All right? Now, dear old South Carolina, and I'm going to read you all this just like I've read you the other stuff, so you can see what they say, and it'll surprise you. 1997. In December, the Bar Ethics Advisory Committee issued opinion number 9736, holding 4.2, barred ex parte communication with a former employee. That sounds a little different, doesn't it? The first justification for the ruling was that the former employee is off limits as a past member of the former employer's control group. That's the exact opposite of what I just read to you from the National ABA. This bars ex parte communication with the former employee because of the past managerial responsibilities concerning the matter in litigation. All right? Very different. Exact opposite, I would say. Considering that he is also a former member of the plaintiff's control group, it is possible that his admissions would bind the plaintiff plaintiff corporation, and his statements may be imputed to the corporation. And then the professor goes on to say the flaw is, with this reason, is that out-of-court admissions by a former employee are not binding and cannot be imputed. All right? Now, this is where it gets hard, okay? You got this case. You haven't brought it yet. You don't know whether you're going to join the truck driver. You got to go see what he's going to say. You might want him as a defendant. If he's no defendant, you're going to be in federal court. If you're going to make him a defendant, you're going to be able to keep it in state court. You may or may not want it in the state court. You may say, I'd really rather be in the federal court, but I got this admission against interest from this driver, and I really want him, and the only way to get it in is for him to be a party, and I'm willing to name him a party and stay in the state court because that defeats diversity. You see what I'm saying? All these things running through your head trying to figure out, well, how do you get an advantage? Where's the best place? All right? There's 100 of these decisions. And then you say, I want to go see so-and-so. He used to be the dispatcher. He used to be head of finance with this defendant company. He's not there anymore, and I want to go see him. And here's the national ABA that says it's fine. And here's the South Carolina disciplinary rules that say, yeah, you better be careful. I'm not so sure that's a good idea. Now, what's the answer? The answer is good, solid, I don't know. All right? The good, solid, I don't know. What I've tried to frame for you, what I want you to pick up, and it reminds me of a good friend who went to, when I was in law school with me, he took professional responsibility twice. All right? I mean, he passed it the first time. He did fine. They just scared the hell out of him, and he was afraid he might miss something, so he went back and took it again. All right? What I want to bring to you, what my message is, don't let these things paralyze you. All right? Learn them for a reason. Learn them to use them. Learn them to call the other guy on the carpet when he's wrong. All right? Learn them to be able to initiate, to be aggressive, to be an advocate within the rules. And the only way to do that is to know the rules. Thank you.
I didn't think he deserved that big hand of applause. Gedney pointed out some things that were really important for you all to know and for me to emphasize. Rules. Our profession is controlled by rules. They're controlled by two sets of rules. They're controlled by the rules of procedure and the ethics rules. And if I could tell you anything in the world, I would tell you to learn the rules. I happen to be on the committee that wrote both sets of rules. When I was a clerk for Chief Justice Littlejohn, he told me when he was a legislator, the most important thing that he learned was to know the rules of the Senate or the rules of the House, and he was the Speaker of the House, and that you had to learn the rules of the game you're playing. And if you knew the rules of the game you're playing, you knew how to take advantage of the rules. I don't know, probably don't know who Wilt Chamberlain was, but he couldn't shoot a foul shot at all. Well, he figured out the rules would allow him to take a run, and he'd run from the foul line, jump from the foul line, and dunk the ball. He made all his foul shots that way. They changed the rule. But until they changed the rule, he had an advantage. I just noticed the other day there was an article in the paper where a high school in Texas, this Texas coach down there figured out if he put his quarterback 7 yards deep, it was considered a punting formation. And everybody on the line was eligible to catch a pass. They've now closed that loophole, but it certainly caused a lot of problems in the meantime. So what we're telling you is learn the rules. We have those rules, like 4.2, Gedney was emphasizing to you, that sometimes they're confusing. And they're confusing a lot of times because we had a bar opinion that doesn't agree with the national bar opinion. Well, I'll say it clear. Our bar committee was made up of a bunch of defense lawyers, and they like it their way. The bar committee for the nation had a much more balanced committee, and they got it the right way. So when you look at opinions, attorney general opinions, bar opinions, whatever, they are guidelines. And sometimes you may have to take a chance and go against one of those opinions based upon what you've learned from other states or other places. What you have to follow are the rulings of the South Carolina Supreme Court. And they give you rulings along the way. I was at one time in the Attorney General's office, and I'd come from clerking with Judge Littlejohn, and Chief Justice Lewis at the time, no relative, but he seemed to like me, or he may not have when you hear the story. He called me over and told me that it was time that lawyer discipline be brought back to the Supreme Court. I said, where is it? He says, well, it's over in Tootie Williams and Kermit King's office. Would you go over there and gather up the files and bring them over here? We're going to start an office of lawyer discipline. Now just think of that. Lawyer discipline within my career was in this private lawyer office. I went over there, and there was one file cabinet with bunches of files in them. I had no idea when they'd come in. I had no idea what the status of them were. And I was to take them over to the Supreme Court. I took them over there, and there were files in there that were as old as 10 years old. Well, so it was a system that didn't work. And so we put together a new system on lawyer discipline, and we started the office, and I started it with myself, who was in the Attorney General's office, and I had other duties, and I had one lady that helped me. If you go over there now, there's probably 5 lawyers and 20 employees, and all they do is lawyer discipline. It's become very, very important. And it's used in litigation, unfortunately. It's used in family court actions, unfortunately. And so when they say professionalism, what they're telling you is to know the rules and stay within the rules. I was given the job of prosecuting a case when I was out in practice. I got an order from the Supreme Court telling me that I was a special prosecutor and I was to prosecute this lawyer for his discovery ethical violations. Well, I'm a lawyer out in Columbia, and I've been appointed to try to discipline a fellow lawyer, and the pay was zero. But there was the court, and they had appointed me, and we did the case. And it resulted in an opinion called In Re Anonymous. And you need to read that. That opinion tells you what happens out there in the legal profession and what people do with the rules. For example, in the old days, you had depositions. Now, let me just go back a minute. The rules of procedure are the most important first step for you to learn in law school. They give you the foundation and the field of play for everything you learn. Everything you learn. Evidence, contracts, torts, secured transactions, everything, those are all litigation topics within a field that is controlled by the rules of procedure. Know them. They are so important. And so within those rules are the discovery rules, which are the biggest and most abused rules that could ever have been invented. They were made to make litigation easier and less expensive. If you read Rule 1, they have made litigation tricky, forever, and expensive. And that is because lawyers use them wrong. And the Supreme Court in In Re Anonymous has tried to correct a little of that. It's gone a little way. And let me explain. In a deposition, used to be, we had lawyers that would cuss out the other client, call them names, do all kinds of things, and the Supreme Court has disciplined lawyers for such action. And then we had the nice lawyer. And you'd ask a question. Was the light green? And you ask the other side. Then the lawyer would say, objection, it is obvious that he thinks the light is red. And then the witness would say the light was red. And so what you had were lawyers giving their witnesses answers by objections to the question. That was eliminated in Re Anonymous. And now I think, I can't prove it, that when the law, you're allowed to say object to the form, or you could allowed to say don't answer it because it's privileged. Those are the two objections you can give. And I think that I'm sitting there and the guy objects to the form, and the same form I've used before, it's a signal. I can't prove that, but I think it's a signal. So what they're doing there is trying to get the advantage. I don't think that's the right way to do it, but, I can't do anything about it. He's allowed to do that. When we had a case, I had an asbestos case, and it was with Mr. Westbrook's firm, and we were bringing a case on behalf of a University of South Carolina, no, it was Bell South, against one of the big asbestos companies. And there was a great statute of limitations question, and my wife, who's a lawyer, was in charge of responding to the discovery of the other side. And during her search for documents, she came across a document that would most likely ruin our case because of a statute of limitations question. She brought the document to us, and all of us on this side said, we have to give it to them, and we gave it to them. And then later on, the judge ruled that we had a statute of limitation, and he used that document to beat us over the head. And after the case was over, the defense, we were all plaintiffs' lawyers, and the defense lawyers on the other side said, I can't believe you gave us that document. I thought, well, my gosh, is that the way they think? I can't believe you gave us that document means to say to me that they would not have given me that document. So you're going to have to make terribly hard decisions in your practice over what to do with the materials that you find on your side of the facts. And that brings me to the most important thing that I can tell you is that your cases are based upon the facts, and you use those facts within the rules of procedure to present your case. Now, what can you do about the facts? You can hide them and be wrong. You can not give them to the other side, which is hiding them, and be wrong. You can try all kinds of tricks to do and hide and change the facts. You cannot change the facts. What your job is to put the facts in the light most favorable. Let's think about this a minute. What does that mean? It means how you present your facts. If you got a man over there who's got scraggly teeth, got a big old fat nose with a wart on it, he's got no more hair than me, and you think to me, you say, man, that's an ugly man. That's one way of saying that the fact of that guy. Another way to say is, I've seen better looking people. The second way is the way you present your case. The first way is a loser. The second way, you got a chance. So you take your facts and you put them in the light most favorable. And you take your facts, and let me explain this. When you have a case you're to present, many times it's impossible to know what really happened. You've got so many facts, and your client won't always remember right. You won't always have the right, all the witnesses. But you will have a set of facts. And you get all of those facts, and you come up with what I call your story. And your story is the best way, the best story your facts will support. That's what you do as a lawyer. And does that mean that's the truth? No. No. We don't know what the truth is. What we do is we try to present the case that's best for our client. We try to present that the light was green. And we do everything we can to present a case that the light was green. The other side is going to try to present the case that our light was red, and we ran the red light. Whether we ran the red light or it was green light is not of what the truth is not there. The truth, as they say, is what the jury says it is. And so we're there to present that as best we can within the rules. Now, discovery, as you got it right at the apple. Nobody likes discovery to answer them. Nobody likes to put down all the information that the discovery requires. I had a case against DuPont that lasted 10 years. And DuPont taught me, I was the plaintiff, every trick in the book to criticize my discovery responses and for them not to answer my discovery. And I can tell you that if you'll learn the rules, let's take, for example, interrogatories. Interrogatories are questions you can ask the other side. And let's say, for example, you ask them a question, what is the expert going to say? And they put in there, the expert's going to say his opinion is that the light was green. And they don't put anything else in there. DuPont took the position, and some judges agree and some don't, that when you put your expert up, he can only say, I think the light was green. Well, without putting his foundations in, without putting why he says that in, without you getting up and giving him opportunity to make a statement as to why he thinks it's green, someone just standing up and saying the light is green is of little value. And the other side would try to get him to explain why he thought the light was green, and we'd stand up and DuPont would say, we object. They only put on their interrogatory answer that he said the light was green. So they used the rules very effectively. When you look at what you're supposed to do under the rules and you follow the rules, it takes a lot of work. It takes a lot of effort. It takes one thing that Gedney told you, which is the most important thing of all. It takes full knowledge of the facts on your side. So if there's anything I can tell you about professionalism, I can tell you that it all ties back into learning the facts on your side. And you learn them as much as you can, as early as you can, so you develop the best story that your facts will support. Now, you heard what Gedney told you about what former employees, and that brings me to a point that you're going to learn, especially as young lawyers. You're going to hear them, the other side, will use ethics as a hammer. Okay. If the other side doesn't say you're unethical a couple of times in the first 3 weeks, you probably aren't doing your job. This is something that's come out in the last 20 years that I think's terrible. And I have been called lots of things, and to include unethical. And I think it's wrong. Because, for example, in the former employees, after they found out that you have contacted them, they'll immediately say, you're unethical, and we're going to turn you into the grievance committee. We had a case where we, against car dealers, and we had a way to let people know we had the suit, and they accused us of violating the law. They accused us of being criminals. Why? Because we were hurting them. And they were going to use that tactic. And that's out there. And don't use it. It's not the way you should treat your fellow lawyers. It is not the way to win. It is not what the rules are for. I now have 3 cases where the other side, now just think of this. I happen to be defending some people, and that's not what I usually do. And I'm defending, in 3 cases, some people, some lawyers. And the other side has turned them into the ethics committee. Now let's think about that logically, okay? They have sued my clients, and they want money from my clients. They want my clients to give them dollars, and they turn them into the ethics committee. Now, if I want dollars from somebody, I'm not going to turn them into the ethics committee. I'm going to try to be a little nice to them because I want my money. And that's what they do, and it makes no sense to me. They have made everybody so mad that they'll never get an offer because they've turned them into the ethics committee And you know what they've turned them into the ethics committee for? What they've alleged in their complaint. And you know what, when you allege something in your complaint is? It's allegations. And you know what your obligation is under our ethics rules as to turning other lawyers in? You turn them in when you know they've committed an ethical violation. I went to West Point, and we had a code, duty, honor, country. We will not lie, cheat, or steal, nor tolerate those that do. Okay, and I got there and I thought, I got to think about this a minute. So I know I'm not going to lie, cheat, or steal, but what about this toleration stuff? And I came to the conclusion that unless I saw someone lie, cheat, or steal, and there was no other explanation in the whole wide world that would explain what he does, I would maybe turn him in. So when you look at ethics, it's my opinion, you don't have to run and turn everybody in just because you can allege something about him. You must know something that is unethical. See it. That's my opinion. So when these lawyers use the ethics in litigation to turn them in for allegations they've made in their complaint, which means they're going to be fought in a civil case as to whether or not there is a cause of action that can be proven, you don't do that. That's just wrong. That's not what our professionalism is for. If you think that our rules say that you turn everybody in you think's doing something wrong, boy, look around you. You're going to have a bunch of people you're going to turn in. So professionalism as we know it are to follow the rules, both the ethics rules and the rules of procedure. If you do that and you apply something, the most important tool to both sets of rules, you'll have no problem in the practice of law. And that tool that you use is common sense. You will find that the law is common sense until the legislature gets in and writes some statute. Then I can't answer what it is after that. But the common law, as we know it, is common sense. And it's very, very easy to look at, easy to understand. So when you're out there, if you look at it that way and you go back to the basics, you apply your rules and you know your rules, you'll have no trouble in the practice of law. Now, I'm going to give these last few minutes just so you can ask Gedney a question. Anybody have any questions? We're glad to answer them. I see you all have a rule like we had at West Point. If someone asked a question, we broke his arm right after that.
Thank you, Gedney and Cam, for being with us today and sharing your views on professionalism and ethics to our future super lawyers. We have a small token of appreciation, totally within the ethical rules. Thank you for being with us.